What are the 3 monthly pension options for permanently and totally disabled injured workers? They are full monthly benefits, but only for the injured worker's lifetime, a significantly reduced monthly benefit to the worker with an equal monthly benefit paid to survivors, or a lesser reduced monthly benefit to the worker with a trailing 50% benefit paid to the survivors on a monthly basis. The injured worker and their statutory survivors must choose at the point the injured worker transitions onto an L&I pension. Workers who have no spouse or dependent children do not have eligible survivors, so will only be allowed pension option 1, which is for full benefits. If, however, the injured worker is married or has financial dependents, all 3 options are available and one must be chosen. I give the following information to all of my firm's permanently disabled clients at Washington Law Center. Option 1 is that you are allowed to obtain your full L&I benefit going forward, assuming no Social Security offsets. The amount of your pension eligibility does not differ from your time loss eligibility on a monthly basis. So if you were receiving $3,000 per month in time loss, your pension benefit would also be $3,000 per month. The only difference is that you would be paid your pension benefit only one time per month rather than having it paid in biweekly installments. The downside of selecting option 1 is that if you die before your spouse or financial dependents die, they cannot receive any ongoing L&I benefits after your death. There is no trailing benefit whatsoever. The pension benefit simply ends on the same day as you die. This will normally cause a severe financial hardship for your survivors, which is probably not how you want the future for your loved ones to go. Because selecting option 1 can financially devastate a surviving spouse and minor children, you are not allowed to select this option unless or until your spouse has signed a notarized acknowledgement agreeing to this arrangement. I normally try to discourage Washington Law Center clients from selecting option 1 if they are legally married. Option 1 is not a good pension option for people who are married unless they have made other lasting and durable arrangements to take care of their dependents, especially their children. On the other hand, if the injured worker has sufficient life insurance to cover their spouse's and children's needs in the event of the worker's death, or if the worker's spouse is already independently wealthy or high-earning, or if the injured worker and their spouse have already filed and are just waiting for a divorce to be finalized, then in those types of limited circumstances, it may still be appropriate to select option 1. After all, option 1 pays the most money in ongoing monthly benefits, so can be the most advantageous. Selecting this option while married, however, is usually a form of high-risk gambling. Option 2 is that the injured worker will be paid an actuarially reduced benefit starting as soon as the pension commences, but the injured worker's spouse will be covered and receive the same dollar amount in benefits for as long as the surviving spouse lives after the worker dies, or until the surviving spouse later remarries. The amount of the immediate benefit reduction depends upon factors such as the injured worker's age and those of any beneficiaries, including dependent children. A typical immediate option 2 reduction in ongoing benefits is around 25%, which is obviously a big hit financially and requires a significant adjustment. But most married individuals should still select this option and cover their spouse to the fullest extent possible. An injured worker's spouse can return to work, obtain higher paying or more work or overtime, or the couple can figure out how to decrease their monthly expenditures in order to make the significant adjustment necessary. We do see workers move their families to less costly areas of the country or even to foreign countries in order to make the pension transition adjustment. But the key is to remember that the pension payment option is to be made as part of long-term planning, not based on the hardship the adjustment imposes here and now. Option 3 is a compromise option that falls somewhere in between ensuring the highest dollar amount of ongoing monthly pension benefits under option 1 and obtaining the highest amount of survivor insurance benefits under option 2. A typical reduction when taking option 3 is about 15% deducted from the previous time loss payment. Now, if a worker has selected either option 2 or option 3 in order to cover their spouse, and then their spouse ends up predeceasing the worker or later gets divorced from the worker, then the worker can apply for a change in circumstances, upward adjustment to their ongoing pension benefits. An actuarial adjustment will be made and increased benefits will be paid, although the benefits will never be able to return to the full option 1 equivalent amount. If you have questions about the 3 industrial injury pension benefit options, please contact Washington Law Center today.